Hello, Colin Manning here. In this video, we're going to look at Chapter 3 of the GDPR, and that deals with the rights of the data subject. So data subjects have very many rights under the GDPR, and these appear in Articles 1 through to 23. So we're going to look at each of these. So GDPR Article 12 talks about the communication between the data controller and the data subject. The data subject has a right to lots of different kinds of information from the data controller, and Article 12 specifies that these communications must be concise, transparent, intelligible, and easily accessible, and using clear and plain language. So that's quite a shopping list of requirements there. And I think it's fair to say that a lot of the communications that data subjects receive from data controllers fall short in this department. Article 12.2 does specify that the data controller can refuse to provide the data subject with certain information if the data controller is not in a position to satisfy himself that the person seeking the information is in fact the data subject. Article 12.3 specifies that the time limit for most of the communications required is 1 month, although that can be extended where necessary. Importantly, where the data subject makes the request in electronic form, then the response should be in electronic form also, unless the data subject requests otherwise. A printout, for example, of a data dump might not be searchable. It might be much less useful to the data subject than the electronic version. Article 12.4 specifies that if the data controller does not respond within the specified time limit, then the controller must respond explaining why, and also provide information to the data subject about how to complain about that to the supervisory authority. Article 12.5 specifies that the information must be provided by the data controller to the data subject free of charge. Now, this is a change from the directive. Under the directive, it was possible to charge a fee for providing the information. There is a provision, though, that allows the data controller to charge in the case of the requests being manifestly unfounded or excessive, in particular because of their repetitive character. This, in essence, allows the data controller to charge a fee for the processing in the case of the data subject, as we might say in Ireland, acting the bollocks. So really, if someone is just acting the bollocks, you can deter that kind of behaviour with a charge, but you would need to demonstrate that the requests are manifestly unfound or excessive. So there is a provision for that, but again, if you were relying on that provision, you would need to have a good paper trail there and have some good documentary evidence of that. Article 12.6 specifies that if the data controller has some doubts about the identity of the person requesting the information, the controller can, take steps to verify that. That might delay the process a bit. In those circumstances, that would probably be acceptable. And in some cases, it may be prudent to do that because, of course, if you release information to someone other than the data subject, well, then there's a whole other set of problems opened up there. Article 12, 7 and 8 are interesting these sections of Article 12 foresee a kind of labeling system or graphic system that might be attached to services or products, I guess services. And these would be something like health labels or health warnings. And the idea is that a standard set of icons might be developed that would advise people about the data processing standards and what's going on in a particular website or particular service. We haven't really seen much of these. I mean, it would be a very interesting graphic design project, perhaps even a business opportunity for someone. But the idea is that you might go to a website and it might be rated in terms of its data protection practices, or as you're going through the process even of doing things, certain parts might be highlighted with different icons and different things like that. We haven't really seen this, so this is more forward thinking. So Article 12.8 specifies that even in the future we might get some standard set of icons that we should use. But for now, this hasn't really happened yet. It's more forward-looking. GDPR Article 13 specifies the kinds of information that must be provided to the data subject at the time when the personal data is being collected. And this is quite an extensive list of information. And like I said, this must be presented when the data is being collected. So this is even before you do any processing. All of this information must be provided up front. And it would be interesting actually to go and look at a website or a service you're signing up for and to see if all of this information is in fact provided. If it's not provided, there's a big problem there. So in Part A, we must provide the identity and the contact details of the controller. In Part B, we must provide the contact details of the data protection officer. So we'll talk about the data protection officer at a later stage, but the data protection officer is a person within an organization that works for the controller or on behalf of the controller that is responsible for the data protection issues. That person is the contact person and the contact point for all the GDPR related issues. Part 3 then says we must identify the purposes of the processing for which the personal data are intended, as well as the legal basis for the processing. So we have to say why we are collecting the data. And then we also have to identify which of the mechanisms we are using to make the processing lawful. So that may be legitimate interest, it may be due to the contract we're entering into, or it may be by consent. But that has to be identified there up front. Part D specifies that where the lawful basis for the processing is the legitimate interest of the data controller, then those legitimate interests need to be specified. Part E requires us to specify the recipients of the data. So if someone else is going to receive this data, who that will be. And Part F specifies that if the data is going to be transferred outside of the EU to a third country, under what circumstances is that going to happen? And that's something we will also look at a bit later. Article 13 specifies that in addition to all that, the data controller will also specify the period for which the personal data will be stored, or if that's not possible, then the criteria that will be used to determine that. So that's interesting. You have to specify how long you're going to keep the data. It may be that that's not possible. But if that's not possible, that's fine. But then how will you decide when it will be deleted? You have to decide that in advance and tell the data subject up front in advance of collecting the data. The controller must also then tell the data subject about the various rights that they have. That includes the right to access and rectification and erasure. So the data subject must be informed up front of the rights that he or she has. Article 13.2c specifies that if consent is the mechanism by which the data processing is being made lawful, then the data subject must be advised that he or she can withdraw the consent at any time. And the data subject must also be advised of the right to lodge a complaint with the supervisory authority. We will talk about the supervisory authorities at a later stage. The data subject must be advised whether the provision of the personal data is a statutory or a contractual requirement, or a requirement necessary to enter into a contract, as well as whether the data subject is obliged to provide the personal data. So, does the data subject have to give the data, or is it just optional? And if the data subject doesn't give the data, what are the consequences of that? All of this must be advised in advance of collecting the data. So even if it's a statutory requirement, even if the data subject has to provide the data, you still have to tell the data subject, well, what are the consequences if you don't provide the data? So they must be able to make that decision. Article 13.2f deals with automated decision making, and that's something we will discuss a little bit later. But if there is going to be automated decision making based on the data that the data subject is providing, the data subject must be made aware of this in advance. And some information, meaningful information, about the logic involved must also be provided, as well as the significance and the envisaged consequences of such processing for the data subject. So if there's going to be automated decision making, you have to tell the data subject, you have to try and explain the logic in a meaningful way, and also what the consequences might be. So again here, the data subject must have all the information before deciding whether or not to provide that information. So this is a lot of work you have to do, and you haven't collected any data yet. Article 14 deals with a scenario where the data controller has data on the data subject, but that it didn't collect the data from the data subject directly. It got it from somewhere else. And this happens when information is transferred from one controller to another controller, or, it may have come by some less appropriate means. So the data controller must provide the identity and contact details of the controller, must provide the contact details of the data protection officer, again, provide the purposes of the processing for which the personal data are intended, as well as the legal basis for that processing, and the categories of the personal data concerned. The data controller must also specify the recipients or categories of recipients of the personal data, if there are any. Now, importantly then, the data controller that got the information from somewhere else must identify to the data subject the source of the personal data. And that's important because it means that if you are merging databases, for example, you need to keep track of the origin of the data. Or if you come by some data somehow, you need to be able to identify where you got that from. I've had personal experience of this, for example, where I've gotten junk mail from someone and I've gone to them and said, where did you get my details? And they've said, well, I got this from somewhere. And I've gone to that person and said, where did you get my details? And they've said, oh, well, I got this from somewhere. And you should be able to trace the data all the way back to its original source. Although in the personal experience I had, the original data was not obtained lawfully. But what's important is that the people who received the data had to keep track of where they got it, where it came from. Now, Article 15 deals with the right of access by the data subject to the data. So if you're processing data on someone, that someone has the right to know what data you're processing. And of course, the first thing they need to know is, are you processing data about them at all? So Article 15.1 states that the data subject shall have the right to obtain from the controller confirmation as to whether or not personal data concerning him or her are being processed. So the first question is, are you processing information about me? If you are processing information about me, then the next questions that follow are the purpose of the processing, the categories of personal data concerned, the recipients or categories of recipient, and whether or not those recipients are in third countries. The data subject is entitled to know for how long the data will be stored, and also about their rights and their rights to complain. Article 15G specifies that if the data wasn't collected by the controller from the data subject, then where did it come from? What's the source of that information? And then, yet again, we have information about the automated decision making and the potential consequences of that for the data subject. So the information that the data subject is entitled to have under Article 16 is essentially a copy of the information that the data subject should have been given when they provided the data in the first place. So it's no surprise that there's some duplication there. Article 15.2 talks about the processing of data in third countries, and that's something we'll look at a little bit later. But if data is transferred outside of the EU, that can only happen under certain conditions. Article 15.3 gives the data subject the right to a copy of the data. And where the request for that data is made electronically, the data should be supplied electronically. And importantly, it should be supplied in a commonly used electronic form. So it must be in a form that they can access it in. Some organizations do a good job of this. Facebook allows you to download everything you've ever done in Facebook and everything Facebook has stored about you, and you can download that as a very large file as it happens, but it can be interesting to see how that works. That could be a fun activity for you to do. Article 15.4 touches on the balancing of the different rights of different people. If the information stored about you also relates to other people, well then the data controller must make sure that in giving you your data, the rights and freedoms of others are not adversely affected. So it's possible to imagine scenarios where that might be the case. Article 16 talks about the right to rectification. So if the personal data that is held on the data subject is inaccurate, the data subject has the right to have that corrected. So in its simplest and most common form, this deals with the issue of credit rating agencies having inaccurate information. So if you took out a loan and the bank mistakenly notified the credit rating agency that you missed a payment when in fact you didn't, and that's recorded on your credit history, you have the right to rectify that information, and you can have that information corrected. And if you recall, we mentioned previously that credit rating agencies and the problems surrounding people's credit histories was one of the driving forces of all of this data protection legislation. The right to rectification can be interpreted quite broadly. There was a case of a student that wanted to rectify the information on his exam paper. That was quite a stretch. The courts found that exam papers written by students are in fact personal data, and so they fall within the scope of the data protection legislation. But the court also found that the exam script was in fact an accurate record of what the student wrote on the day. And so the student was not entitled to correct that record. Full marks for imagination, full marks for giving it a lash. But that just gives you an idea of how far away from correcting erroneous credit history record you can get. You can stray quite far with the interpretation of the GDPR. If for some reason the data controller does not want to change the information in the record, the controller can provide the option of appending supplementary information. So the data subject could say, for example, I did in fact pay this, or the person that reported this as being not paid neglected to mention that the products that were delivered were faulty, or something like that. You can insist on something being appended to the record if the data controller doesn't want to modify it outright. It's a brave data controller that would say no, but obviously if people could write their own credit histories, they wouldn't be much use either, and there wouldn't be a business to be had in maintaining them. Article 17.1 deals with the right to erasure, or the right to be forgotten. The story of the right to be forgotten begins with two ads that appeared in the Spanish newspaper La Vanguardia on the 19th of January and on the 9th of March in 1988. So the ad was announcing the auction of properties that were being sold as part of a process to recover taxes that were owed to the state. So the ad was placed in the newspaper by the state agency that was auctioning off the properties. One of these properties was owned by a Señor Costeja González, who owned the Social Security Agency some money, and his name appeared in the ad. Now, it's not clear whether his name was published as part of a name and shame campaign to deter tax fraud. That happens in some countries. In Ireland, for example, the Revenue Service does that. Now, Señor Costeja González was concerned then when many years after, anyone Googling his name was directed by Google to the newspaper website. He complained to the Data Protection Authority in Spain, that's the Agencia Española de Protección de Datos, and he wanted the newspaper to either alter or remove the pages so that the data relating to him no longer appeared. And he also wanted Google to stop linking to those pages when they searched for his name. Now, in 2010, the AEPD rejected his complaint about the newspaper because the publication of the information was lawful. And not only that, but it was actually published at the request of the government. Like, it was the government that placed the ad in the newspaper. It wasn't even there on the newspaper's initiative. So that was clearly lawful. It's also possible that the agency was a bit reluctant to go rewriting history. People often say that journalism is the first draft of history. Now, while this particular, ad was not really of major significance or anything, the idea that you would go around telling newspapers to change what they wrote after the fact, or to remove things that they wrote after the fact, that clearly made people uncomfortable, I think. However, the APD did uphold the complaint against Google. So it felt that Google should stop linking to the newspaper when people searched for this man's name. So Google then took the case to the Spanish High Court, which is known as the Audiencia Nacional. Now, the right to be forgotten is often discussed when people are talking about the GDPR, but this case was actually decided back when the Data Protection Directive was in force. So all of this happened under the Data Protection Directive. So the court was dealing with the Spanish law that was the transcribed version of the Data Protection Directive. However, there were some issues as to how the directive should be interpreted, and so the case was referred to the European Court of Justice. So this case was case C13112. You can download the decision and read it if you want. It is quite a long decision because there were also issues to do with subsidiaries and things not related specifically to the data protection issue. Among the interesting things the court said was, it noted, it cannot be accepted that the processing of personal data carried out for the purposes of the operation of the search engine should escape the obligations and guarantees laid down by Directive 95/46. It also noted that processing of personal data carried out by the operator of a search engine is liable to affect significantly the fundamental rights to privacy and to the protection of personal data, since that processing enables any internet user to obtain through the list of results a structured overview of the information relating to that individual that can be found on the internet. Information which potentially concerns a vast number of aspects of his private life and which, without the search engine, could not have been interconnected or could have been only with great difficulty. And this is what separates Google's obligation from that of the newspaper. Although the information is out there, it's not as readily accessible without Google. So the court ruled that as the data subject may request that the information in question no longer be made available to the general public on account of its inclusion in such a list of results, those rights override, as a rule, not only the economic interest of the operator of the search engine, but also the interest of the general public in having access to that information upon a search relating to the data subject's name. So here the court is trying to balance the economic rights of Google to do what Google does and the rights of the public to have access to information, but also balance those rights against the rights of the individual. And it came down on the side of Costeja Gonzalez, saying that his right overrode those other rights. It did note, however, that would not be the case if it appeared for particular reasons, such as the role played by the data subject in public life, that the interference with his fundamental rights is justified by the preponderant interest of the general public in having, on account of its inclusion in the search results, access to the information in question. So if Costeja Gonzalez was the Prime Minister of Spain, well, that would be a whole other thing. He would have fewer rights in this case. So with this judgment, the Court of Justice of the EU ruled that a search engine operator is responsible for the processing that it carries out of personal data that appears on web pages published by third parties. And it upheld the right to erasure of the links. So the links by Google to that data must be deleted. The data itself remains intact. And the ruling tried to balance the right of privacy and data protection with the legitimate interest of the public to access that information. It also distinguished between public figures and private individuals, and it tried to get the balancing act right there. So when the GDPR came along then, the right to be forgotten was written into that to reflect the change in the law. So now any individual living in the EU can go to Google and fill out a form and request that links to certain sites be removed. You can actually have a look at that. You'll notice that there appear to be some unusual places here. These are actually places that are in the EU, sort of. You see that the UK was still here, and therefore we also have Jersey and the Channel Islands. Some of the more unusual ones are parts of France that are not geographically in Europe, but are legally part of the French Republic. Needless to say, this decision was quite controversial. Lots of news organisations were quite cross, understandably. Many people felt that if something was important enough to be published in a newspaper or to be published on a news website, that it was important enough to be left there. And that removing links from Google would be harmful to society and to public discourse. At one stage, the BBC even took the extraordinary step of publishing a list of pages that Google had been asked to take down. But actually, if you go and have a look at that list, it's not full of criminals hoping to hide their past or politicians hoping to forget about various indiscretions. A lot of them are stories about people that it was kind of private, and really the world has no business knowing about it 10 years on. So if Google does link to a website, a news site, for example, that has information about you and that information is outdated or no longer relevant, there's a set of criteria and you can fill out the form and Google will consider whether it will remove those links or not. There was an attempt in Europe to extend the right to be forgotten extraterritorially, so that if you were in the EU, you could insist that Google removed links to articles about you when someone did a search in the US or in South Africa or in Japan. But that wasn't successful. So if someone does a search for you in the US, they would still get all of the results that they would have got before the right to be forgotten came into force. When you search for an individual's name, Google does say that some of the results might be missing as a result of the right to be forgotten. But of course, it does that for everybody. It doesn't do that just for the people who've had stuff deleted, because that would kind of be unfair and would undermine the whole point, because it would say to someone, haha, look, here's what we have, but there's stuff we couldn't show you, so you need to keep looking. It doesn't do that. That would be demonstrably, grossly unfair. So in Article 17.1 then, the right to erasure goes into detail, and the data subject shall have the right to obtain from the controller the erasure of personal data concerning him or her without undue delay when the following applies. And it's only one of these things need to apply. So where the personal data are no longer necessary in relation to the purposes for which they were collected, or if the person withdraws consent, or if the subject objects to the processing pursuant to Article 21.1. We haven't looked at that yet, but that's the automated decision making. Or if the personal data have been processed unlawfully, if they have to be erased for compliance with the legal obligation, or if the personal information collected was in relation to services that were offered under Article 8.1, which relates to children. Article 17.2 acknowledges that any information that has been collected may have been shared with other data controllers. So if the data subject asks for the data to be deleted from your system, it also requires you to advise all of the people you shared the data with downstream that a deletion request has been issued. So you have to keep track of everyone you gave the data to in order so that you could meet that obligation. Article 17.3 specifies the circumstances in which the erasure request can be refused. And so if the processing is necessary for exercising the right of freedom of expression and information, So this might apply to, journalism. So if you're a journalist working on a story and the person you're writing the story about isn't happy about that, they can't use the GDPR to have you delete all the information about them. Obviously, if there is a legal obligation which requires the processing, well then, the controller has to meet that obligation. There's a public health exception. Again, this seems to make more sense now than it did when it was first written. We've seen that it's possible there can be extreme public health scenarios that may require the individual privacy rights of data subjects to be overridden. Part D talks about the public interest in scientific or historical research. And 17.3e specifies that the erasure request can be refused in the exercise or defence of legal claims. So, if you're involved in a court case with someone and you have information about them that's relevant to that case, they can't decide that you should delete all that. GDPR Article 18 talks about the restriction of processing. So a restriction on processing isn't a request to delete personal data. It's a request to put a freeze on the processing of it. And so there are a number of scenarios in which this freeze would be preferable to erasure. So in Part A here we see that if the accuracy of the personal data is contested by the data subject, well then the restriction can be put in place while the controller verifies the accuracy of that data. So this restriction would typically be at the request of the data subject. So if you believe your credit history is inaccurate, you can request a freeze on that, a restriction on that, while an investigation is being carried out, while you are asserting your claim that there's something wrong, and the data controller then has time to verify that. Even if the data processing turns out to be unlawful, the data subject may request that a restriction is placed on it rather than an erasure. And the reason the data subject might want that is that it could help with the investigation. It could make it possible then to trace back where things came from, for example. It could also make it possible to identify the full extent of the processing. So where the processing turns out to be unlawful, the easiest thing in the world for the controller to do is just to delete the data. But of course that deletes the evidence also. And there may have been useful information in there for the data subject. I mentioned earlier a personal example where I had some junk mail and I was able to trace back where that came from. For each of the data controllers I communicated with, I asked them to put a restriction on the processing. Even after they acknowledged that they shouldn't have had it, they weren't in a position then to delete it. They could only stop processing it. So you could see how if you are designing a database even, you need a flag in there now for your database where you have a sort of do not process flag for information that is still part of the database but can't be used. In Part C here, we can see that the controller may no longer need the personal data, but they're required to keep that for the establishment, exercise, or defence of legal claims. So the data subject may want them to keep it even after they don't need it anymore. Part D provides for a restriction of processing in scenarios where there's automated decision making. Again, we'll look at that a little bit later. This keeps cropping up. And that gives some time for the parties to figure out, what's going on, whether everything is above board or not. So once the restriction on processing has been put in place, then the data can no longer be processed by the data controller. except with the data subject's consent or whether there's a legal case requiring that information. And once the restriction has been put in place, Article 18.3 points out that the restriction can only be lifted once the data subject has been informed. Article 19 then addresses the issue that we mentioned earlier about downstream versions of the data subject's personal data. So the data may have been shared or given to other data controllers, and whereas there's a restriction placed on the data in the data controller's database, the data controller must also communicate to all of the downstream holders of that personal data that a restriction has been put in place. In the GDPR, these are called recipients, and there's a definition of that. It's a natural or legal person, public authority, agency, any other body to which the personal data are disclosed. Article 20 is a very interesting article, and it is more driven by competition incentives than it is data privacy ones. So the idea here is that a data subject should have the right to data portability. So imagine that I have been banking with a Bank of Ireland for 20 odd years, and I've built up a history and a relationship with that bank, and I have a very good credit history and lots of other wonderful things about me. It might be hard for me to move to a different bank and start again. Well, Article 20 talks about the right to data portability, and I should be able to take all of my personal data with me when I go somewhere else. You could see how this would be useful for people trying to change car insurance companies. Your history is very important to an insurer. I think what this article was hoping for was that there might have been 3 or 4 different social networks, and that users, depending on their preferences, might have had the option to move, say, from Facebook to some other social network, while at the same time keeping all their contacts and all of their posts and all of their connections. As it is, even if there was a competitor to Facebook, and there doesn't seem to be anyone now or on the horizon, but even if there was one, it would be very difficult to leave Facebook because you'd have to leave all your data behind when you move. So I think the hope here was that if you operated a social network and you didn't have very good privacy standards, well, your customers might up sticks and move to the other social network that offered more privacy. We're not really seeing that. We do see it a little bit perhaps with messaging apps, but of course for messaging all you need to take with you is your contacts, whereas to bring your whole entire social network history with you would be more difficult. Anyway, the idea is that you should be able to take your data in machine-readable form and bring it with you somewhere else. The final part of this chapter of the GDPR raises some interesting issues about the processing of data and the interaction between personal data, big data, and AI. And it talks a lot about automated decision-making and profiling. And it's fair to say that these concerns are quite forward-looking and are an attempt to constrain technology that is still only developing and still only being deployed. We hear a lot now about digital redlining. Redlining was the practice of denying services, either directly or otherwise, to residents of certain areas based on the racial or ethnic composition of those areas. And this was a term coined in the 1960s. And this was a practice of banks that denied credit to people based on where they lived. So they would have had maps of the city, and depending on where you were from, you were either deemed creditworthy or not. And of course, in segregated US cities, this amounted to deciding that you were creditworthy based on whether you were black or not, because segregation meant that your address was a good proxy for your race. And service providers literally had maps that would designate the good areas and the bad areas. Even now, geography can be a proxy for socioeconomic background. We often get jokes in Cork and Dublin about Northsiders, and people in Dublin are very concerned about their postcodes. There is an interesting line in a song by Eminem where he says, "Claiming Detroit when y'all live 20 miles away. Look at y'all running your mouth again when you ain't seen a mile road south of 10. And if you've ever been to Detroit, you know that the grid in Detroit has miles numbered from south running north, and the dodgy parts of town have lower mile road numbers. When I was in Detroit, a friend of mine said we never go south of 12. So in Detroit, your address is literally a score from 1 to 20 based on your socioeconomic background. It may be that downtown has become gentrified now. It's been a while since I was in Detroit. But certainly this song here highlights the connection between geography and socioeconomic background. And that's the thing with data generally, and big data in particular. Innocent pieces of information can be proxies for other kinds of information. And you can combine relatively innocent pieces of information to reach conclusions that might be less appropriate. So redlining generally is making decisions about individuals based on factors that are not relevant. And on a good day, that's unfair. On a bad day, it's discrimination, it's racism. Now, in the US, they actually introduced a law in 1968. Things got so bad, and it was the Fair Housing Act. But we can see this kind of problem coming up again now when it comes to data processing and processing big data in particular. In Ireland, discrimination is prohibited. So if you make decisions that affect people based on their gender, marital status, family status, sexual orientation, age, disability, race, colour, nationality, or ethnic or national grounds, or membership of the traveller community, well then that's discrimination. So if you make decisions that affect people adversely on any one of these criteria, that's straight up discrimination and that's prohibited. Furthermore, asking for that information is typically prohibited as well. So you can't ask someone's religion on their job application or their sexual orientation. You would get into a lot of trouble just for even asking. However, one of the difficulties we have now, and one of the difficulties posed by AI and big data, is that it's possible with a high degree of accuracy to guess what religion someone is. Or it may be possible with a high degree of accuracy to figure out if someone is gay. So if you have all of someone's social media posts, if you have all of their purchases, if you have their location information, you may be able to infer with a high degree of accuracy information about them that it would be unlawful for you to collect and use otherwise. And even if you weren't doing anything nasty and weren't discriminating against people, the decisions made by algorithms might be unfair. We all have horror stories of funny ways in which AI and big data have let us down. But what if you were applying for car insurance? Or what if you were applying for a house loan and the artificial intelligence dropped the ball? That could have serious consequences for you and could impact badly on you. So the GDPR seeks to protect people against algorithmic decision making that might go wrong or that might be unfair. Facebook caused quite a lot of fuss when it became clear that it had secured a patent on a scheme that decided your creditworthiness based on the creditworthiness of your friends. And so there was a lot of talk about how if you were going to the bank, you might have to start deleting from Facebook the friends that had low credit ratings. So some people felt this was particularly unfair and particularly harsh. So the GDPR provides safeguards against automated decision making that might be problematic. So Article 21 seeks to protect people against automated decision making. In Article 21.1, where the data processing is being processed in the public interest or in the legitimate interest of the data controller, the data subject can object to that. In Article 21.2, the data subject can object to profiling for direct marketing. So we all see ads on Facebook and Instagram that attempt to offer us things they think we might want to buy. And that's based on our social media profiles. Facebook and Google think they know things about you. They think they know who you are and offer you goods and services based on that. And in Article 21.5, the data subject can object to being profiled. So the data subject can specify that he or she does not want to be tracked, for example, and can object to ads based on profiles. Article 22 seeks to protect individuals from things going wrong with automated processing. So if a decision is based solely on automated processing, including profiling, that produces legal effects concerning him or her, the data subject can object to that. So you can object to decisions being made solely using automated processing. There are exemptions from that, however, and paragraph 2 goes into those. So if that automated processing is necessary for entering into or performance of a contract between the data subject and controller, well then you can't object. But the data controller would need to articulate why it's absolutely necessary for entering into that contract. The individual member state to which the controller is subject might actually lay down measures and safeguards that make automated processing okay. And of course, the data subject might consent to the automated processing. Now, where automated processing does occur, the data subject, at a minimum, has the right to obtain human intervention and to express his or her point of view and contest the decision. So if a bank's algorithm refuses to give you a mortgage, you can at least require human intervention and a human review of that decision because it was based solely on automated processing. Now, in any event, automated processing cannot be based on the special categories of data that are in Article 9.1. And those are the racial, ethnic, religious, the special data that you really don't want to be processing anyway. So your automated decision making cannot use those unless you have the explicit consent of the data subject or it's in the public interest. Finally, then, there are some restrictions placed on the rights of the data subjects. And these appear in Article 23. These are pretty much what you would expect. So in 23A, we have national security, B, defence, C, public security. There's the prevention, investigation, detection and prosecution of criminal offences, and then other important objectives of general public interest. So these are quite vague, but these would be overriding national security or public interest concerns. We also have in F the protection of judicial independence and judicial proceedings, the prevention, investigation, detection and prosecution of breaches of ethics for regulated professions, and a few other restrictions. Article 23.2 points out, though, that any restrictions that appear in paragraph 1 must be properly articulated, and they must contain specific provisions that specify the purpose of the processing, the categories of personal data, the scope of the restrictions, and the safeguards to prevent the abuse or unlawful access or transfer. So it's not enough for a government to say, oh, we're doing this for defence. They must explain a bit more than that, explain what's being collected and why. They must also specify how long it's going to be stored. They must assess the risks and rights and freedoms of the data subjects and the right of data subjects to be informed about the restriction, unless, of course, that undermines the restriction in the first place. So, in summary then, data subjects are entitled to know who is storing information about them, what information is being stored, why it's being stored, and for how long. They are also entitled to assess the accuracy of that information, and if they're not happy, they can object to the storing of the information. They can have the information corrected or deleted. They may also withdraw consent that was given at any time. So data subjects have quite extensive rights. Now, the next thing we're going to look at are the obligations of the data controllers. And as you can imagine, that's a mirror of the data subject's rights. For each right a data subject has, there's a corresponding obligation that a data controller has.